Okay, let's get straight into it. We're doing a deep dive today into a really serious issue here in South Africa, unlawful financial schemes.
Indeed. Things like Ponzi schemes, pyramid schemes, they unfortunately continue to cause significant harm.
Significant harm is right. They can be devastating for everyday retail investors, but also for businesses caught up in them. The source material we looked at mentions cases like Crypto Mzansi and Mirror Trading International.
Yes, those are quite prominent recent examples, unfortunately highlighting the scale of the problem.
Exactly. So for this deep dive, we really want to zero in on the legal tools South Africa actually uses to fight back. Specifically, we're looking at asset forfeiture and liquidation.
Two very important but distinct mechanisms.
That's the plan. Our mission, if you like, is to try and unpack these processes. What are they really? What are they trying to achieve? And maybe most importantly for you listening, what could they actually mean if you find yourself impacted? Both for maybe getting some money back and also underscoring why vigilance is just so critical.
Absolutely. And it's crucial, as you said, to understand that while both asset forfeiture and liquidation involve managing assets under the court's watch, they stem from different legal bases and have different primary goals. The sources really stress understanding this distinction. Sometimes they might run in parallel in these complex scheme situations, but they aren't the same thing.
Right. So let's break them down. Maybe we can start with asset forfeiture. Could you walk us through that one? What is it, legally speaking?
Certainly, asset forfeiture in the South African context is primarily governed by the Prevention of Organized Crime Act. That's Act 121 of 1998. We'll probably just refer to it as the Act going forward.
Okay, the Act.
Fundamentally, the Act gives the state, specifically through bodies like the Asset Forfeiture Unit or AFU, the power to seize assets that are shown to be connected to criminal activities. It's about targeting the proceeds and the instrumentalities of crime.
So taking away the profits, essentially, and maybe the tools used to commit the crime.
Precisely. The core idea is to hit criminals where it hurts financially and to disrupt organized crime by removing the resources that fuel it. It's not primarily about compensating victims initially, though that can be an outcome. It's about law enforcement and crime prevention.
Okay, and how does it actually work? Is it just one step, seize the assets?
No, it's typically a structured two-stage legal process. The first step is usually obtaining what's called a preservation order from the High Court.
A preservation order, like freezing the assets.
Exactly like freezing them. Think back to the Crypto Mzansi example mentioned in our sources. The AFU reportedly used preservation orders there as a crucial first move. It stops the suspected illicit assets from being dissipated, hidden, sold off, spent while the legal process unfolds.
That makes sense. So you secure the assets first. What happens next?
Well, after the preservation order is granted, the National Director of Public Prosecutions, through the AFU, then needs to apply for a final forfeiture order. And to get that, they have to satisfy the court, on a balance of probabilities usually, that the assets are indeed linked to the specified unlawful activities. They need to prove that connection.
So there's a burden of proof on the state.
Yes, definitely. If the court is satisfied, then the forfeiture order is granted and the assets are officially forfeited to the state.
And what's the ultimate aim then, once the assets are forfeited? You mentioned disrupting crime, but what about the victims of the scheme?
That's a critical aspect. While the primary aim is disempowering criminals, the Act does provide mechanisms for recovery. Once assets are forfeited, they can potentially be used to provide some form of restitution or compensation to the victims of the underlying crime. It creates a potential pool of funds.
A potential pool, okay. That's important hope for those affected.
It is. And another key feature of the Act, which is important for fairness, is protection for innocent third parties.
So if someone unknowingly got involved or has a legitimate claim to some of the assets.
Correct. If someone wasn't involved in the unlawful activity, but has a legitimate legal interest in the property that's been preserved or is facing forfeiture, they have the right, under the Act, to apply to the court to have their interest excluded from the order.
That's a vital safeguard, isn't it? To avoid penalizing innocent people.
Absolutely vital. It ensures the process targets the actual proceeds and instrumentalities of crime, not legitimate holdings.
Okay, so that's asset forfeiture, state-led, crime-focused, freezing, then potentially forfeiting assets linked to crime, with possibilities for victim recovery and safeguards for the innocent. Now, let's switch gears. Liquidation sounds, well, different. How does that work, particularly when we're talking about a company involved in one of these schemes that then collapses?
It is quite different, yes. Liquidation, or winding up, as it's also known, is fundamentally a civil process. It's not directly tied to proving criminal activity in the way forfeiture is. It's governed mainly by the Companies Act and the Insolvency Act.
Civil, not criminal. Okay.
Its primary purpose is to manage the orderly winding up of a company that is insolvent, meaning it simply cannot pay its debts as they fall due,
So companies run out of money, basically.
or its liabilities exceed its assets. The goal of liquidation is then to gather all the company's remaining assets, sell them off, and distribute the proceeds fairly amongst all its creditors, everyone the company owes money to, according to a legally defined order of preference. Shareholders might get something, but usually only if all creditors are paid first.
And how does this liquidation process start? Does the company decide or?
It can happen in two main ways. It can be voluntary, perhaps initiated by the company's shareholders or directors if they see the writing on the wall. Or, more commonly in the context of collapsed schemes, it can be compulsory, initiated by a creditor, or even sometimes employees or SARs, applying to the court for a winding up order because the company isn't paying its debts.
So investors in a scheme, if the company running it collapses, could potentially apply to have it liquidated.
Yes, as creditors, they often can. Once a liquidation order is granted, the company directors lose control, and the court appoints a liquidator, or sometimes joint liquidators.
Okay, the liquidator. What's their job exactly? What powers do they have?
The liquidator steps in to take control of the company. Their role is crucial. They have to investigate the company's financial affairs, identify and secure all of its assets, wherever they may be, and then critically, they need to determine who the company owes money to, the creditors, and how much.
So a sort of financial detective and manager rolled into one.
In many ways, yes. And they have significant powers. One really interesting power highlighted in the source material is the ability to scrutinize transactions that happened before the liquidation started.
Before? How far back?
Well, for instance, under insolvency law, liquidators can look back sometimes up to 2 years or even longer in certain circumstances for what are called voidable dispositions or undue preferences. This could include things like, say, the company selling assets to a related party for far less than they were worth shortly before collapsing.
Ah, trying to hide assets before the end.
Potentially, yes.
Yeah.
Or paying off one favored creditor just before the collapse, disadvantaging others.
Huh.
The liquidator can apply to the court to have such transactions reversed, set aside, and recover that money or property back into the company's estate.
Wow, so they can actually undo past deals.
Under specific legal conditions, yes. It's a powerful tool aimed at swelling the pot of assets available for distribution to all creditors fairly.
That seems incredibly important in scheme cases where funds might have been moved around suspiciously.
It absolutely is. And this is where you see the intersection with unlawful schemes. Even though liquidation itself is a civil insolvency process, the collapsed company is the entity that owes money, often primarily to the investors who were defrauded. So liquidation becomes the mechanism for trying to recover whatever assets remain within the company's structure for those creditors.
Right, and the sources mention the role of attorneys here.
Yes, very strongly. Navigating a liquidation, especially a complex one involving a potential financial scheme, requires real expertise. Qualified attorneys specializing in insolvency law are pivotal. They help creditors prove their claims, they advise the liquidator, they might challenge unfair transactions, and generally work to ensure the process is conducted properly and fairly to maximize the recovery for creditors. It's not really something you can navigate effectively on your own.
Okay, so we have forfeiture driven by the state, targeting criminal assets, and liquidation driven by insolvency, managing a company's wind-up for creditors. Could you maybe crystallize the key differences for us? Why is it so important, as the sources stress, for someone affected to understand which is which?
Okay, let's boil it down. The core objectives are fundamentally different. Asset forfeiture under the Act is linked directly to criminal prosecution or proving unlawful activity. Its main goal is stripping illicit gains from criminals and deterring crime. Recovery for victims is often a secondary, though important, consequence managed through the state.
Right, crime focus.
Liquidation, on the other hand, is triggered by financial distress insolvency. Its objective is managing that insolvency in an orderly way, focusing on a fair distribution of the company's available assets amongst all its legitimate creditors and potentially partners or shareholders, according to civil and commercial law principles.
So, insolvency-focused civil process.
Exactly. Now, there's a commonality, which can sometimes cause confusion, Both processes involve the management of assets under judicial oversight. In forfeiture, you often have a curator benalis appointed to manage the preserved assets. In liquidation, you have the liquidator. Both are officers of the court in a sense, with custodial roles.
Oversight and management in both.
Yes, but the legal basis, the procedures, who drives the process, the state versus creditors, the company itself, and critically, the rules for how any recovered funds are distributed are quite distinct.
And those different rules and procedures directly impact affected parties, I assume.
Profoundly. How you stake a claim, what you need to prove, who gets paid first, the timelines, these can all differ significantly between a forfeiture scenario aiming for restitution and a liquidation scenario dividing assets among creditors. Understanding these divergent approaches is crucial.
So, for you listening, knowing whether the primary legal action happening in a scheme you're affected by is state-led forfeiture or company-focused liquidation, or perhaps even both concurrently. That knowledge is absolutely key, isn't it? It determines how you might even begin to try and recover something.
It really does. Engaging early and getting the right legal advice, as the sources strongly suggest, seems paramount. You need to understand which process applies or how they might interact to correctly position yourself and pursue any potential claim effectively. It's complex terrain.
It certainly sounds like it. So, to sort of summarize where we've got to, asset forfeiture and liquidation are clearly vital, if complex, legal frameworks in South Africa's arsenal against these damaging, unlawful financial schemes.
They're indispensable tools, yes. And while navigating them can be daunting for victims, understanding the basic purpose of each, whether it's potential restitution via forfeiture following criminal action, or recovery as a creditor via the civil liquidation process, and crucially, seeking timely and specialized legal counsel can significantly improve the chances of recovering at least some losses. It also contributes in a broader sense to upholding economic integrity by ensuring there are consequences.
Absolutely. Which leads us, perhaps, to a final thought to leave with you, the listener, drawing from what we've discussed and what the source material implies. Considering these intricate legal avenues, asset forfeiture and liquidation, and acknowledging, as the sources do, the persistent challenge these unlawful financial schemes pose in South Africa, what does this ongoing battle really suggest about the delicate balance needed? The balance between ensuring these complex legal processes are efficient and effective after a scheme collapses versus the perhaps even greater need for proactive, widespread public vigilance to prevent people from falling victim in the first place. Certainly something worth reflecting on.